Um, I'm supposed to talk about the most frequently asked questions about the heritage law. And I'm thinking that, I should tell you what the questions are and not the answers. That's because no case has been brought and before the Supreme Court and nothing has been decided yet. So if I give you my opinion, it will be just that, my opinion, and it's not even binding. Number one, we always get reports of, let's say, a church that's a national cultural treasure. And then someone emails me and says, the priest wants to construct a building beside the church. Is that okay? What's the answer? Officially, under the law, even without the Supreme Court decision, if a building is a declared national cultural treasure or important cultural property or a national historical landmark, the owner will have to go to the proper cultural agency for permission. So, for example, in the when I talk about the priest wanting to construct something beside a church that's a national cultural treasure, they will have to ask permission from the National Museum before they can make such changes. So that one, the answer is very clear. Ask permission from the National Museum. What if the church is both a national cultural treasure and a national historical landmark, which is under the jurisdiction of the National Historical Commission? Where should they ask permission? The law is silent as to what to do if it's declared by both, but again, to be safe, ask permission from both. We're currently trying to make the technical working group between the National Museum, the National Historical Commission, and the NCCA to meet more often and talk about these issues. And hopefully we can come up with a written policy soon. So that's the other one. This one is the gray area, and it's more iffy. So if I ask the question, I tell you what the question is, my answer will really be as good as yours. For example, what if there's a building and you're sure that it's at least 50 years old? The last incident where this applied was this bridge in Dupax, Nueva Vizcaya. What can they do with the bridge? Can they touch the bridge? Can they demolish the bridge? Can they build a road over the bridge? Who says that it's okay? This bridge is not declared a national cultural treasure or a national historical landmark. Who says that you have to ask permission from a cultural agency? Raise your hand, please. Yes? Okay. Well, the law says that if a structure is at least 50 years old, you have to petition the National Historical Commission for the removal of the presumption that it is important cultural property. So what happens if the National Historical Commission says that it is important cultural property? Then we go back to question number one. So it becomes declared property, therefore you need the permission of the NHCP. In the meantime, well, that presumption has not been removed. It cannot be demolished, it cannot be fixed, it cannot be repaired unless with the permission of the NHCP. And then this is where the controversy starts. What if the NHCP says that it's not important cultural property? Does that mean that it can now be destroyed? And this is the part where I don't want to be quoted, but yes, that's precisely the point of the law. if it's not presumed important cultural property, then it's like any other property. You can do whatever you want with it. But that's just NHCP. Is there anything that will stop the National Museum from declaring it important cultural property for a reason other than that it's significant to our national history? And my opinion, again, this is just my opinion, nothing stops the National Museum from declaring it important cultural property. So you can still file a petition with the National Museum saying that it's significant in some other way. Next question, national artists. This, among the heritage circles, you already know that Mandarin is supposed to be redeveloped, and it was designed by a national artist, architect Leandro Locsin, and the landscaping was done by Mr. Ildefonso Santos. What can be done if property was designed by a national artist? Similar to structures that are at least 50 years old, those properties are presumed important cultural property. No one has gone to the Supreme Court testing the meaning of presumption of cultural property for the purpose of protecting it. No one. So again, this is really just my opinion. Again, the person files a petition to remove the presumption that it's important cultural property. And if the NCCA says that it is not important cultural property, then they can do whatever they want with it, even if it's designed by a national artist. But if it is an important cultural property, we go back to the rules in question number 1. There are some gray areas. For example, what if they propose that we'll do this, we have a plan, we will follow the rules of adaptive reuse? Can the NCCA say that, okay, you can do that, provided you follow these plans? My answer is, I don't know. Because what if they say they'll do this, but then they decide, no, we want to do something else? Can the NCCA go to court and then say that, no, you promised, this is what you should have done? And that's private property. I don't know. No one's tried that yet, but that would certainly be an interesting case. The other frequently asked question is heritage houses. We get a lot of requests for grants asking us to fix up heritage houses. These are privately owned, and some are being used as museums, some are still being used as homes. But no one disagrees that these are heritage houses. In fact, some of them have been marked by the National Historical Commission. There's a provision of the law that says that there are supposed to be heritage agreements where the owners agree as to what can or cannot be done with the houses. In exchange, they're going to allow some public use. And the agreement is supposed to be annotated in the title. As far as I know, no guidelines have been made for this yet. And our committee is still trying to figure out what sort of help can be done to privately owned houses, considering the prohibition for spending public money for that. I still think it's a gray area because it's possible that privately owned houses fulfill a public purpose. And there is already a Supreme Court case decided in, the title is Manosca versus Court of Appeals. And this involved the NHCP acquiring land where the Iglesia Ni Cristo founder was born, and they were going to put a marker. And the Supreme Court said that this is not an act favoring a religion, but it was a valid exercise of eminent domain, that the acquisition of land was a valid public expense, since the purpose was to promote Philippine history. And the same argument can be made for heritage houses. But again, that's up to the COA and the Supreme Court. The other one, and this is the one that I am most afraid to talk about is the issuance of cease and desist orders.